Greetings and hello, everybody. It's me, Brian Burke. Welcome. It is Monday. It is 6 o'clock p.m. and thereby it's time for Shihab Burke to be live on YouTube to talk about whatever we want to talk about in the world of immigration, as well as answer your questions. Conspicuously absent, neither on my left, neither on my right, is my partner and pal, attorney Sam Shihab. And realizing that, I better turn off that little bar that says his name there. Good thinking, Brian. Going to turn that off right now. There you go. You get to see how the sausage is made, as it were. You get to see my keyboard and mouse. Anyway, welcome. I am Brian Burke. I am the same Brian Burke. I forgot to pick up his microphone here. And I'm here to talk to you about a fun immigration topic. That fun immigration topic for today is H-1B stamping, actually. It's H-1B stamping changes and risks. There have been some changes to H-1B stamping in the last couple months, which I think are worth talking about, and, well, we haven't talked about live in this venue here of YouTube. So we're going to hit on those topics today, and we are also going to do, as usual, answer some of your questions. I am totally looking forward to it. So, without further ado, let's talk about what's going on in the world of H-1B stamping. And why is it important to talk about H-1B stamping? Because this is probably the most #1 question that I get asked about. Brian, I'm going for stamping. What should I do? Brian, I'm going for stamping. Is it a good time? Brian, I'm going for stamping. Any sort of permutation on that. So what's to say about it? I think, well, we're going to go down a list of things that are interesting to talk about, and we'll tell you about them here. So first thing on the list is Visa Dropbox. So for a long time, for a couple years there, they were very, very nice to us on Dropbox stamping. 48 months was the amount of time that they allowed you. You know, if you had a visa issued that was from the last 4 years, 48 months, you could be eligible for Dropbox. They put that down to 12 months. 12 months is a bit rough because, well, that means there's just going to be more people out there that are going to be in need of visa interviews. And if there are more people in need of visa interviews, we can expect longer times for interviews. And I think that's going to be a recurring theme in everything I tell you guys this evening, that we are going to expect to see longer times on H-1B interviews for a couple reasons. One of them, Visa Dropbox. Only 12-month look-back period on that instead of the 48 months we had for a long time. There you go. What else do we have on the H-1B stamping changes and challenges front? The DS160. So as an attorney, I'm going to tell you my #1 best advice on DS160. Be honest about it. Be accurate about it. Because boy, does the government love an inconsistency. They do love it when they see one thing on a DS160 form and they know something else to be true. They're going to bring it up to you. They're going to harangue you about it and give you a hard time if something is not right. Now, oftentimes people would come to me, right before an interview, and they would say, "Hey, Brian, I goofed something up on my DS160. How can I tell them it's changed?" Well, you can't really change a DS160 once it's submitted, but one thing you could always do another one. Do another DS160. Bring another DS160 to the interview. And historically, the consulates were more or less fine with that. Give a new DS160 to let them to fix something, and that's that. Now, they now have sort of a policy at the consulates that says your DS160 confirmation number must basically match the one you used with the time you made an appointment. And that can cause some challenges here. So the hypothetical is you make your appointment with your completed DS160, right? You say, "Ooh, shoot, I need to do something with a new DS160." If you go to the appointment with that new DS160, they're not going to take it. They should cancel the interview and force you to reschedule and force you to repay the fees again. And that's just going to be a problem, is the bottom line. So the high-level answer is DS160. It must be accurate at the time you submit it, and it must be the DS160 you take to the interview must be the one that you submitted at the time you scheduled your interview. Let's see here. What else do I have on my list? I keep on going from my paper notes, but I have it up here on the monitor as well, which is all the better. So let's see here. Oh yeah, Document upload. So there's also a fun little requirement here that NBCs are shifting towards a requirement that all supporting documents must be uploaded at least 72 hours before interview through the CEAC web portal, the CEAC. That's the Consular Electronic Application Center web portal, which is where you do the DS160 itself. So that's kind of a change. Historically, you don't really submit electronic documentation with the CEAC. So I guess what I'll tell you about this is I kind of like it. Basically, it's difficult sometimes to submit documents to the consulate physically because you have to get them to the location. For example, if I have a client elsewhere in the world and they need documents, well, gee golly, getting them to the physical location wherever they're at is a bit of a logistical challenge. Now, the problem I would have with uploading them is I still expect that there's going to be scenarios where you're going to want to submit original documents to the consulate, and I'm questioning their ability to take them. A classic example is, hey, if your employer wants to give you, confidential tax returns or something to take with you to the consulate, kind of a classic H-1B stamping sort of scenario, that the consulate might be less willing to accept those in physical, sealed envelope form, which is the classic thing we would do. There was basically, if there was a concern about company financial information on H-1B, the employer would hand, a sealed, for the eyes of the consulate only, envelope from the company saying, here's our financial information. And I guess if they're taking their submissions electronically, it sort of requires the employer to put those documents electronically into their employees' hands to submit them. Not something I like. So the big thing about electronic document uploads through the CEAC portal, great. It sounds like it might make things move a little bit faster. But in defense of the current process, I don't think that the average consular officer is looking, at your interview documents much time at all before an interview occurs. Because I've never heard any evidence to suggest that that's the case. When it comes to interview documents, I get the impression that officers look at your documents in your DS160, minutes before the interview, because that just seems to be how it is. Occasionally, you get somebody who's sort of well versed in you, but I wouldn't call it the norm. So, if I had to pick a #1 trend in H-1B visa stamping, that is, I'm going to put this in the category from our heading or our title of challenges rather than changes, is Department of State compliance reviews. These are the #1 types of challenges that we have in terms of visa applications at the consulate. The typical scenario is this. You go to an interview and you think you have an okay interview, and then your employer gets an email from the Department of State from a section that's basically about, integrity or review, and they start asking your employer questions. And also, they'll typically start asking, if you're, say, an H-1B worker who does IT consulting, they might send an email to your vendor company if there's a vendor involved. They might send an email to an end client company if an end client's involved. And they will be soliciting information to confirm that what you told them, at the interview, yes, I'm going to work for company ABC and I'm going to provide consulting services to company XYZ. They're going to want to contact those clients, to the people involved, to make sure that what you're saying is true. And I appreciate the general need to do this because not everybody is honest, and the U.S. government wants to make sure its T's are crossed and their I's are dotted to make sure that the people that are coming to the consulate are giving authentic and accurate information, that they're just giving visas away willy-nilly. The challenge here, though, is that in my perception, at the consulate, for the government, everybody seems to merit, intense scrutiny. For example, I can think of a company, a small business that sent an employee to the U.S. consulate for a marketing manager role. Company has small operations in the United States, larger operations in India, and with those two things together, they have me reasonably convinced that they need a marketing person in the United States. If a lot of their activities, their business activities in the United States, but their employees are offshore, it's fathomable that you could have a small group of people in the United States and a bigger team that does the substantive work abroad, and that could require a marketing person in the U.S. Great, fantastic. And that guy, that nice guy, got an H-1B compliance review request to his employer, and his employer gave him an honest explanation. We're a small business in the United States. Our clients are in the United States. We have a couple people here in the United States who manage the business. We have people offshore, part of a foreign subsidiary that generate the work product. And basically, we need people in the United States to market and manage the business while the people offshore take care of the work. Perfectly legitimate H-1B. Great, fantastic, nice. That poor guy has been in an H-1B at the consulate compliance review forever. And that is sort of part of a bigger trend that I don't really like about H-1B compliance reviews. They tend to kill people's visa applications. Imagine it. You go to the consulate in January, and then you find you get they want to do some work. They want to put you in administrative processing while they review this matter. They contact a vendor, end client, your employer, and that stuff takes time. The delay I guess the short answer is the delay that's introduced, that's caused by the Department of State review process, is that it can kill people's offers of employment. If there's a client, or if there's just a company, if there's just a company that wants somebody in the United States to come and start working for them, being stuck at the consulate makes them reevaluate. And that's sort of it. One of the most common H-1B stamping worrying scenarios I have is the following. It's, Brian, I have a minor criminal thing. A minor criminal thing that, Brian, I don't think that I'll tell you, I don't think it should impact your eligibility for a visa. But if the consulate doesn't agree with me and they just decide they want to think about it for a bit, you're stuck outside the United States when they're thinking about it for a little bit. And in that time, that can kill your job in the United States. If you're working directly for an employer, the employer can say, well, this guy's never coming back, I'm going to replace them, or I can only have them working remotely for so long. If you're an IT consultant with an end client, the end client's got to get their business needs met. So if you're not coming back anytime soon, they will replace you with somebody else, and so will your employer, because you were making that money for them there, and if that project doesn't continue, you don't have a job. So really, those compliance reviews, those employment verification reviews from the consulate are an absolute killer. And on top of all this, something that is just sort of developing here is the concept of, enhanced vetting at the consulates, enhanced vetting everywhere in U.S. immigration. If you haven't read the news stories, if you haven't been following the news, the general sort of immigration headline that unifies everything is that they are being more thorough, more interested in you at every point of the process. And this, at the consulate, what is that going to look like? In theory, it should mean more of these compliance reviews where they contact vendors and clients, employers to verify the details of your work, that your offer of employment is legitimate. More looking into your background, looking into your social media, looking that sort of thing. At the border, more looking into your phone, your text messages to see what's there. So if I was talking earlier in this presentation about, what does, changes and challenges in the H-1B process or H-1B stamping process look like? It looks like more time, and more time for the government to do its enhanced vetting sort of job to slow down getting your visa application. And if I start thinking back in time, man, slowed down visa applications are an absolute killer for people. It can kill a future in the United States, that's for sure. So that's maybe my sort of thoughts on H-1B stamping, changes and challenges. Changes, more processes that allow them to sort of, look into your background. And challenges are sort of the classic ones. It's those the compliance reviews by the Department of State, which are the absolute killer, and I'm only going to expect to see more of them as time goes on. So, again, I'm not here, well, I am here by myself. I'm definitely here. I am not here with Sam Shihab today, but because he's doing a bit of traveling, we thought he might be able to be back today. Just didn't happen for us. But the bottom line is, it's that time of the presentation where I will take a deep dive into your questions and see if I can answer them for you. But it wouldn't be a presentation without stopping by our website, immigrationquestions.us, which is back up and running after a little bit of a hiccup last week. So I have a couple questions here from immigrationquestions.us that we have not yet answered, and I will try to answer them. Because these are from April 3rd, and the last time we were here live was April 2nd. Fantastic. So, let's see here. From Harsha, Brian and Sam, background, EB2 priority date, India, April 24th, 2013. Only have an I-140. Employer won't support another I-140 in EB3. Downgraded to EB3 in 2020. Upgraded back to EB2 in 2021 via TUB. Question, given my priority date will likely be current in EB3 at the end of the immigration calendar year, my employer advises against filing a TUB to downgrade to EB3, fearing US confusion and case limbo, USCIS confusion and case limbo. What do you do in my situation? It's not, I guess the short answer on this one, Harsha, is it's not a crazy thing to think that USCIS does get a little bit confused when you can put in a transfer underlying basis. But when I think about your scenario, I think about, you know, the visa bulletin, and I think about how close EB3 and EB2 India actually are. And this is, and as I pull it up here, I believe it's about 3 months separating them. Let me see here. Final action dates for employment, it's, yeah, EB2 India is on 1st of January 2013. EB3 India is on 1st of April 2013. February, March, April, 3 months. Now, 3 months doesn't seem like a long time, but in visa bulletin times, that's, you know, can be an eternity. Sam has been quoted recently saying, yeah, you know, it seems like for every, you know, every 6 months it takes a year. You know, and that doesn't sound crazy to me. I mean, I just remember the bad old days where, you know, every month it would move a week or so, if you were lucky. Meaning it could take a really, really long time to move from, you know, it could take a long time for your EB2 date to get current. And the bottom line, it seems like EB3 is going to be current sooner for you. So the priority date of April 24th, 2013, you're so close to current. You can't do the TUB yet, but it's reasonable minds can differ on these things, but that's the sort of scenario where I just only see it worthwhile to do a transfer underlying basis. I mean, if you are going to be, you're so close to current in EB3. In January, where does January 2013 come? I don't know. All I know is that been sort of for the last maybe year or so predicting that we are going to be back on the bad old days of the visa bulletin of slow movement. Let's see here. One more question here from D. Barty. Priority date September 2014 with EB2 downgraded as amendment to EB3 in 2020 with 485 concurrently filing and filed TUB to EB2 in 22, all with employer A. I moved him to employer B in 2023. And how can I transfer I-45 to the new employer B under EB3 petition? And last sentence mentioned you have to file two I-45J, but TUB dates aren't current. So here's what I will tell you about transfer of underlying basis. A transfer of underlying basis is you saying, hey, I want to move to a different I-140. And from what I'm hearing from DeBarty's scenario is that all of these things, all of the perms, all of the I-140s are with employer A. If they were with employer A, you need to have the support of employer A to go back to get yourself into the EB3 category. And that's a big problem. You have to, I mean, that's a conversation you have to talk with them. If, to be clear, there's no requirement that you be working for the employer that is offering you permanent employment on a supplement J or an I-140. But you have to, well, that's kind of it. You don't have to be working for them, but they have to be willing to offer it. And if you've left and moved on to company B, you might have a problem getting company A to sign back on board to do a downgrade or a TUB back to their EB3 case, especially if you're not joining their company. So my short answer for, you know, if you want to be in EB3 and you're feeling like you're trapped in EB2 because you have left that company to do your I-140, I would say you need to talk to the company to do your I-140 to see whether they're willing to take you back or offer you that employment again, essentially. So hit that immigrationquestions.us with all those questions. We do take those during the week. I'm not gonna bother putting the sign up there because, well, I'll put it up for a second, but it's gonna produce this little bar that says Sam and my name underneath it, and Sam's not here today, that's why. I chose to not do it, but remember, immigrationquestions.us, it's the one you will know because it's the one above my head. Go there. If you come up with any fun immigration questions for us during the middle of the week, that's where we will check them out and bring them up to you here first in our sessions. So, gonna hit those questions that we have here on the main screen live. And so I have a half a question here from Abhishek, and Abhishek, if you're still here, put the whole question in the questions or the chat area again, because I will give you the public service announcement. If you put in questions before we go live, it's iffy as to whether we get them coming through. So here's a good question, though. Can you comment about how much Consulate knows about my history? How to best prepare for difficult questions? So high level is, okay, a couple things you should know. USCIS claims to keep your immigration file forever. So if you've ever told the US government, ABC in the past, and you tell them XYZ now, that can look like an inconsistency. The bottom line is difficult questions. As an attorney, I'm going to tell you that you are under oath when you submit your DS160, when you're being interviewed at the consulate, and you have to be accurate in your information that you give there. Because if you don't, you're potentially engaging in immigration fraud. It sounds a lot like you, and that's sort of that. I don't think you intend to do that, but sorry, SMS call. I'm an attorney, I'm an immigration attorney first and foremost, and I have to sort of give that public service announcement. So how to prepare for difficult questions? It's to anticipate them. And to anticipate them, I'd say talk to an attorney about, what they really mean. There are a lot of times I talk to people about, Brian, I'm really stressed out about ABC. If they ask me about ABC during the green card interview. And for me, as an green card, well, I'll change it to a stamping scenario. I'm really stressed out about ABC. And I will tell you, don't worry about ABC, because oftentimes there are things that people think will be an issue, and they just aren't. Just not a legal issue. There are things, they might be something they never asked about on a visa application, or it might just be something that's totally irrelevant for the purposes of visa eligibility. So there is that. And how to prepare for difficult questions? I mean, my theory of it, reasonable minds can differ, but it's to sort of run them into the ground. Because, when I'm thinking about difficult questions, I'm thinking on a visa application, you said consulate, so I'm thinking about a visa application. I'm thinking, making sure your answer, my number one thing, first and foremost, like I said earlier, is making sure your answers to questions are accurate. Sometimes getting the accurate answer to a question requires a lot of work. For example, there's a question on the visa application that asks, have you ever been arrested? And I've had to do a lot of research into that for somebody, because somebody's like, well, I was kind of with the police. I'm not sure whether I was arrested. Well, so I guess the point is, how do you prepare? You really dig deep in those questions. Probably need to talk to an immigration attorney about that to really kind of figure, do those questions matter, and what are the actual proper correct answers? Speaking of that, keep in mind that we are here in a live internet venue in a public space, and I'm not taking questions exactly live here. I'm taking them on a delay. So just please keep that in mind, and this obviously doesn't create an attorney-client relationship. We're just trying to give you some general information. If you hear something that you like here, talk to an immigration attorney of your choosing about it or anything else, and try to get some good information there. From Runyon, while on an E2 visa, can I do a different full-time job while taking care of E2 related business? No. E2 visas are an area near and dear to my heart. And I'm gonna presume that you are the primary E2 visa applicant, Runyon. You are the primary E2, the primary E2 applicant. Those folks are required to work for their E2 employer. Now, dependents of E2, the primary E2 person, they can work for whomever they want, and there you go. So, going to keep on moving on here to questions from Empire, and let's see here. What impact do you see the current uncertainty in the economy having on immigration? Well, that is a question, Empire, that I think about. Maybe not specifically, maybe in that not exact phrasing, but I am a guy of many minds on immigration. First of all, I like immigration. There's a reason why I've stuck with it for the past 14 years. I like bringing people to the United States. I like that process. I think the world is a very small place, and I think increasing the bonds between nations and people is a good thing to do. But I also think about it and I think about, in that aspect, I think, is uncertainty in the economy going to deter people from coming to the United States? So despite, economic, let's call it turbidity right now, I don't think that there's a great deterrence of coming to the United States for a lot of the people who are coming here. And that's that. I don't think that I am going to see I'm not seeing people saying, Brian, I'm up and leaving this country. I'm more, seeing concern and anxiety from people saying, I want to make sure my stuff is in order. I'm paranoid right now. I want to make sure that I'm not caught in something, problematic. If I'm a permanent resident, I want to become a citizen. If I'm undocumented, I want to straighten that out. If I want that sort of thing. But I don't really see that economic impact. And for those who don't know, we do a ton of employment, immigration, and people are still doing employment immigration. That's for sure. So, I mean, I think about this a whole lot, Empire. Sometimes I think about it from a business perspective because I'm an immigration attorney. That's what I do. But I don't really get the message from people, because I talk to a lot of people about immigration, that they are down on the United States at this time. I'm sure that anybody in our audience can name me 10 different exceptions to that statement, and that's fine. But I'm not seeing any sort of overall downtrend in that. Let me see here. Can you comment on the current situation where DHS is terminating status for F1 students for various infractions? What are possible options to get back in status apart from asking for reinstatement? A great question, Empire. Just sort of, and a very sort of wise thought from the same agency that revoked your status given that low. So I've talked to several people who are experiencing this issue. To get everybody on the same page, check the news headlines. There's been lots of cancellations of student visas. And let's talk about what that means. There's two things they're doing. One, these students are getting emails from the U.S. consulate in their home country saying, hey, we have canceled your visa stamp in your passport. Additionally, they're getting emails from their school DSO, the designated school official, the person who manages the SEVIS student visa program for the school, and saying, hey, ICE has canceled your SEVIS record. And what does that mean for that student? It means without a visa stamp, you can't leave the United States and come back in. And without an active SEVIS record, you can't go to school and maintain your student status. They've effectively, terminated somebody's ability to maintain their student status. Empire, I think you're a person who's very wise, because you're saying that it doesn't seem likely that reinstatement is going to be allowed from the same agency that just terminate your status. I think that's a pretty reasonable position to take. Whether anybody views these visa revocations or the student visa SEVIS terminations, from whether they view them as right or wrong or anywhere in between, all I can tell you is that it is clearly reflecting an intentional program from the present immigration authorities, and that's that. They're doing what they want to do, and if they want to, and going back for reinstatement doesn't seem to be an incredibly likely solution. Now, there's reasons why you might want to do that anyway, to sort of protect your rights and get that. But I mean, I can't but think, Empire, the next step for the people who have been had their SEVIS records terminated is to receiving notice to appears to start them up on removal proceedings. Yet to be seen, but it seems like that's a distinct possibility. So where I think that next step is, it appears to be litigation. To give you an idea, I mean, I started getting calls regarding this situation on Thursday or Friday, and it seems to me that there is no real, aside from reinstatement, there is no real practical way to challenge the termination of a SEVIS record, and so rather no administrative way, which immediately points me to litigation, suing the government to basically say, you know, you guys screwed something up, you guys did not do something right procedurally, and that's it seems to be the way to go. Why do I think that's the way to go? Well, because they leave you with no other option, I guess. And here's where, as an attorney, where I have to be a little bit irritated about the way they've done this. Again, if they have a legitimate grounds for revoking a student visa, I cannot argue with it. If somebody has violated the rules, that such them made them ineligible for student status, that's fine. If they're just enforcing rules that that weren't enforced in the past, I can't as thoroughly or with gusto. I can't argue. You know, if you've broken the rules, you've broken the rules. I can't really argue with that. But my problem with it is sort of a classic attorney problem with a lot of things. It's about procedure. If they're out there canceling people's, you know, SEVIS record, their student status, without giving them notice, without giving them the means to say, wait a minute, before you go doing that, here's why you shouldn't. That's where I have to be upset, and that's the sort of, you know, argument that's likely to come up in court. It's you did this without going through the right process, and that's really that's really kind of it for me from an attorney's perspective. It's a matter of process. That's sort of it. You know, think about say an H-1B scenario. If USCIS thinks that you're not in H-1B compliance, they'll send a notice of intent to revoke to your employer, and your employer has the right to answer that and say, hey, here's why you're wrong in this. Here's why the facts that you're saying merit revocation, you know, do not. Here's more facts. And I think that's really where these SEVIS issues fail. I'll tell you that I have talked to a couple people about that, and the ones I've talked to have all been, they've said, yeah, I had a criminal thing that was dismissed. A criminal thing that was dismissed. And that, as I think about my immigration rules, that's not the sort of thing that should impact your eligibility for visa. You know, if you were in the wrong place at the wrong time, and you get caught up in something and didn't do anything wrong, immediately the case is dismissed. In theory, that seems like it could catch you in this SEVIS F1 related dragnet. And again, you know, there's a big question as to what policy allows the government to do this, right? That's an important question that has to be answered, and, you know, that's individual for everybody. Did you do something wrong that makes you ineligible for student status? But the thing and that's a quite different question for everybody. For some of them, it's criminal things. For some of them, it's, you know, political activities that they think undermine the interests of the U.S. government. But for everybody, it's not being given an opportunity to respond. And that's really the interesting thing, the interesting part of that for me from an attorney's perspective. So let me see here. Wesley Sundara Singh says, totally unrelated question from my previous one. Is it safe to travel on AP with validity until 2019? No immigration issues so far. So this is where I look at Wesley's question and I see it says 2019 there, and I wonder if it's a trick question, but I don't think it is. Maybe you meant 2029 because you could have gotten one of those in 2024. So the answer is, it is a strange time for immigration. This quote unquote, and for travel, this quote unquote enhanced vetting has, you know, resulted in big time problems for certain people. And when people ask me the question, you know, Brian, is it safe to travel? And you know, it's a perennial question. It's a question I've been getting the entire time I've done my job. I would say that the generally, and Sam, if you're watching out there, somewhere you're going to start rolling your eyes in a second, where I'm going to say the first level answer is the only person guaranteed entry to the United States is a U.S. citizen with their passport in hand. Below that, there are tons of people with legitimate reasons. People with visas who are coming in to comply with the terms of their immigration status should reasonably be allowed to enter the United States. The answer is, if you read behind all of these stories where people, are getting harassed at the border or harangued at the border, and with some sort of, and there's a great big shock about it in the news articles, for example, I would say that there's a lot of scenarios where if you read the underlying facts about those news stories, somebody has done something to violate the immigration rules. And that's why they got, either turned around or detained, arguably so. Or it's arguable they violated the rules. Some of them have been very clear to me. Some of them have said, I think that's, perhaps dubious as to whether or not they violated the rules. For example, those protesting. And the short answer is, nobody has that crystal ball, Wesley. Until things settle down, I kind of have to say, if you can avoid the travel, avoid the travel. But if you need to travel, it's not an immigration attorney decision to make. The answer is travel is never truly safe. Is never 100% safe, and the risks have gone up to some degree. I don't think anybody can say exactly when, but yeah. So, I've gone a little bit long. Remember, we're trying to do that half-hour thing here, which means Sam and I will be back on Monday, and we'll see how he's doing. But I'll take this last question for Empire. So, are they required to send notice of intent for an F1 visa? I know it's part of the H-1B regulations. Does it also apply for F1? The short answer is I could get into a long conversation on F1's status, but the answer is there is some process due. You can't just taking somebody's status away without giving them the opportunity to respond is well, that's sort of that, and that's what any sort of litigation on this subject would be about. It's that, and we are sort of it's more about this particular scenario. I mean, maybe my problem, Empire, is it's not whether I've never seen a notice of intent to revoke for an F1 visa. I'll admit I haven't looked at the regulations for that aspect of it, but it's these people haven't gotten that. And the answer is it's a general concept in U.S. law called due process. It's that the government can't take something away from you without going through certain procedures. And that's the fundamental issue here. And that's what I expect a lot of this litigation will be arguing. Well, it is not exactly 6:30. Is it in fact 6:39? But I think I'm going to wrap things up for this meeting. Come back to us next week, because not next week, on Wednesday, because Sam and I will be back together in full force, double the voices, double the loudness. Head on over to immigrationquestions.us, which you should see above my head right now. I do love a good logo. I do love it above my head. Send your questions to us during the week so we can check them out during the week and bring them up here live at the top of the show. And hey, have a good week, everybody. I don't know where you're at, but it's a little bit cold here in Ohio, and well, we're going to get over that. We're going to have a good